I'm off. Thank you. Can I go?
Good morning, Your Honors. May it please the Court, and with the Court's indulgence, given the Commonwealth's position on both the cases, the Commonwealth would be combining both of its arguments on 33 and 34, obviously not limiting the defendant, either defendant, but just the Commonwealth felt this was the most efficient use of everybody's time. For the sake of clarity, I will refer to one juvenile as juvenile 33, which is based upon the docket number for juvenile 11033, and juvenile 34, which is the docket number for 11034. It's the Commonwealth's position in this case that the motion judge, who would be the trial judge, in excess of 3 months before the trial of one of the defendants and the trial date of the other defendant, juvenile 33's trial date had been set for the end of September. Juvenile 34's trial date had not been set at all. That in May of 11, when he had his hearing, that at that time he had nothing before him except for 15-month-old, very dated, very brief headlines from some internet sites before him, and that this was insufficient as a matter of law for him, actually it's an abuse of discretion standard. I go beyond the matter of law. That is an abuse of discretion not based upon the case law for him to have made a decision to change the trial at that time.
Now help me. The move is still within the same division of the juvenile court.
It's within the same division of the juvenile court, but it goes outside the county into Plymouth County, out of Barnstable County, and the crime occurred smack in the middle of Barnstable County in Barnstable.
And what is your basis for claiming that the Commonwealth has standing to complain about a transfer within a division but outside of the county?
Well, it's without of the region of the, it's out of the county.
Okay.
A change of any court for these reasons must be based upon Rule 37, that you can't have a change in anywhere for publicity. The change was based on a publicity. And to the extent that the judge made, and I may jump around a little bit, so I'm sorry.
So is it, if this case were in Lowell and the judge said too much publicity in Lowell, I want to move it to Woburn?
Lawrence. But if it moved to Lawrence, you'd have a problem, but not to Lowell, not to Woburn. Is that right?
No, I think any time you move it from one court where it's scheduled and it's brought originally, whenever it is going to be transferred to another court, there has to be the following of the procedures and the findings and the rulings that show that it is not an abuse of discretion in this case to move it.
Now, are you saying within the same county?
This was not within the same county.
No, I understand that, but Justice Gant's example was within the same county.
Any time it's moved from one court, when you physically have to move all the papers from one court to another court, it needs to be a finding that there is not, if it's not some mechanism pursuant to the statute or a statutory ruling, say you've got a case that's sent to another place for a jury trial, there's a mechanism of a court, that's different. But
do you disagree with the judge's ruling of law where he says the judge should not take into consideration as a factor in determining whether a change of venue should be ordered, that it's in the public interest that the trial take place in the county where the crime occurred, citing to Commonwealth versus Morales? Do you disagree with that? Is he wrong?
I'm sorry, I missed the long quote, Your Honor, I'm sorry.
The judge should not take into consideration the very factors that you're saying are somehow so critical. Are you saying he's wrong? I mean, is Commonwealth versus Morales, does that not support what he did?
I suppose what he's saying is he's doing it for the wrong reasons. He's here doing it for reasons that are not based in the record, that there have to be, it's the Commonwealth's position that, yes, there have to be some reasons.
So otherwise, the Commonwealth has a right to have it in this first court?
The Commonwealth...
Is that the position, that the Commonwealth somehow has a
No.
right to have it
No,
there?
and we're not making, and I know the defendants have raised this per se argument, but that's not the Commonwealth's position. The Commonwealth's position is not in every single case. It must be tried to be seated. The Commonwealth's position that is in this case, because there was such an insufficient showing of the reason for the change of venue, that the judge had to at least try to seat the jury first before, because there was such an insufficient showing. The Commonwealth has never stood for the proposition that you can never change without, that you must always try to seat a jury before, the Rule 37 says there's this discretion. The Commonwealth's position is that in this case, it was a clear abuse of discretion. There was never, the Commonwealth was never given an opportunity to address any of the evidentiary issues which the judge raises. All we had was this non-evidentiary hearing. The defendants don't even raise logistics as a problem, but the judge somehow comes up with these logistical questions, and some questions which the Commonwealth's position he's not entitled to take judicial notice of. And the Commonwealth does address that in its brief. Commonwealth, contrary to what the defendants say, it is addressed in the Commonwealth's brief. And that if the Commonwealth had had the opportunity, we could have addressed these issues that the defendant, that trial court had.
Ms. Haller, isn't the standard of review here what the single justice did?
Both what the single justice did and in terms of, my position is that since Your Honors said that there was no other remedy, that's what the order said, I'm focusing more on beyond the single justice to the underlying issue, in meaning that the Commonwealth has met its burden of showing that it had no other remedy, so therefore we look beyond the single justice's ruling to go to the underlying case.
But that's not all you have to show to get 211 Section 3 relief. You're supposed to show that there's something that warrants the exercise of extraordinary power, something that goes beyond this.
Right, which
And I'm having trouble seeing how you made any showing at all in that regard.
we made a showing in that the Commonwealth has no remedy
But
from...
that's not all you need to show.
That's what it was granted upon, with all due respect. Is that we have a showing there was a clear abuse of discretion by the trial judge, and that in making his findings and his rulings of law, he had insufficient facts to change 2 juvenile murder trials from trials in the county in which they were tried, and it was not based upon anything in the records that was before him at that time, except documents that were dated from December of 2009 for a decision that was made in May of 2011. And I know that in both of their briefs, both defendants attempt to add cases, and in some circumstances they're adding facts that were decided, that didn't even exist until 6 months after the judge made his decision, and I would rest on my motion to, in opposition to the motion to expand the record on that. But it's just, as I think as my brief points out, that it's the Commonwealth's position that there was a clear abuse of discretion, given that we have such far-out trial dates. There was really no evidentiary showing, which was the defendant's burden. The Commonwealth doesn't have the burden here. The defendant has the burden. And this is the only opportunity for the Commonwealth to be able to challenge what it sees as an improper ruling by the judge, an improper procedure by the judge. You know, if it gets sent back and then we have another procedure and do it right this time, and the Commonwealth is given an opportunity and is given that chance to address these issues that were raised in the judge's memoranda, which have no basis in the findings of fact. And then if the defendant wants to present all of these things that go way beyond the scope of what was presented to the motion judge, then at that point, then we can have all of that. But we need a full, fair hearing on this issue. This is, I'm not saying that the Commonwealth's position of having its case tried in the county of the jurisdiction it absolutely doesn't trump the rights to a fair trial. But we haven't got there here. The Commonwealth has the concern.
Is there any basis on which to think that the Commonwealth could not fully vindicate its interest in prosecuting these juveniles in Plymouth?
I don't believe that's the issue. I believe the issue is that the citizens of the Commonwealth have the right to be tried.
What's the answer to that question?
I don't know. I don't know, because with
Well,
the
if you
citizen.
can't establish this, if you can't establish that, then why is this a substantial issue that we should be deciding?
Because the Commonwealth is being denied the Commonwealth was denied the opportunity to address these issues before the judge decided them. We were blindsided by the judge's findings that there were all of these evidentiary
It'd be
problems.
one thing if you said you were blindsided, and oh, by the way, we are very prejudiced by this because we can't really reasonably conduct this trial up the
Well,
street.
it's a prejudice to the citizens of the Barnstable County, when the Commonwealth, as the representative of the citizens of Barnstable County, to have such a case as this to be tried, or at least have a proper procedure where there's an analysis, a thought-out, fully aired-out analysis on this issue before you move it off Cape, away from 15 towns, a very large region, where you have the opportunity to try this. And I see my time is out. If there are no further questions, thank you.
Good morning, Your Honors. John Cunningham on behalf of Juvenile MM. I'd start by suggesting that Mass Rules of Criminal Procedure 37 anticipates aggressive use of judicial discretion to ensure a fair trial. It does so in two ways, one of which is it allows for the judge to sua sponte determine that there is sufficiently prejudicial information to require or in the exercise of discretion to indicate that it would be better to move the trial. That's one way. And the second is it defines the language of the rule is that the defendant may not receive a fair trial. It's not that he shall not. This is may not. It explicitly directs itself to the discretion of the judge. The notion here that this judge did not have sufficient information to make this call completely ignores the findings of fact made by the judge, which, by the way, is what the Commonwealth did in its brief. It didn't address the findings of fact made by the judge. The Commonwealth didn't address the findings of fact made by the judge. The Commonwealth didn't even address what the standard is for abuse of discretion. I've said in my brief, and I maintain here, that this is a frivolous appeal.
Could I ask you, is it a change of venue if you're within the same division?
And that was brought up before the judge. I don't think it is a change of venue.
Well, doesn't venue go to where the crime occurred? And isn't that a county thing? It's not a division of the court.
Well, the juvenile court is a different animal, if you will.
I mean, Rule 37 speaks about if they order the transfer of a case to another division or county for trial. I just don't know whether.
Right, and this is the same division.
Within the same division, whether it even is within Rule 37. That's my question.
Well, whether it is or not, certainly the judge framed his decision in that. Well, he framed his decision in two different respects. One was the pretrial publicity, and the other was the administrative concern that he had, which was discussed amongst counsel. I don't know whether or not that was provided to you, but that was the subject of a lot of conversation between all counsel.
But the Barnstable facilities.
Yes. And I believe that, and I'm not totally familiar with the case, but Smith versus the Commonwealth, 420 Mass. 291, 1995 case, there was a change of venue there for administrative convenience within the district court. Now, my understanding is that the issue was not the change of venue. This was just, but it was noted in passing that there was a change of venue for administrative convenience. It wasn't challenged by the Commonwealth, so I'm not suggesting that this court reached a decision in that case, but certainly there was a recognition that that is a legitimate concern for a court. I am a little bit flummoxed as to what to say because I do not understand why this case is here. The judge had ample evidence. The Commonwealth, in its motion to strike, the motion to expand the record, says, well, we only provided cites. That's ridiculous. That's like saying that you can't, a judge couldn't read a law review article because it was only cited, that somehow the law review article would have to be given to the judge. The judge's findings make clear that the judge read the publicity. The judge was aware of the publicity. In this court in McCowan recognized that the judge in any district is presumed to know what's going on in his or her district. And in fact, the findings of the judge amply demonstrate that to be true.
What do you say about the Commonwealth's contention that it was blindsided?
How? I don't understand it. That the sites were there. Everybody knew about the publicity. This was something that had been discussed many times before. How were they blindsided? You can say that, Judge. Where's the evidence for it? I don't understand it.
What about the staleness of the publicity at that point?
Well, you know, one of the things that the judge, in terms of the McCowan recognition of a judge knowing his or her district, the judge said that there are going to be trials that are coming up, and there would be a resurgence of publicity. That was, in fact, borne out, and that's one of the reasons why we've moved to expand the record on appeal. This judge knew his district. This judge knew exactly what was going to happen. It did happen. And
Has the adult been tried
the adult was tried, yes, and convicted.
and convicted?
Yes.
What's the trial schedule now?
There is none. We're waiting for this court. I mean, and with respect to that, this case happened when my client was 13 years old. He's now 17.
And it's been held all that time?
Yes, and he can only be held until he's 18, which means that even in the worst of all possible circumstances for my client, by the time this case goes to trial, they can maybe hold him for 6 months. So excuse me if I'm being a little bit overstating this, but this is a frivolous appeal that has only delayed this trial. The other thing is that although the government has, in its argument, backed off from its brief, there is a very clear statement in the brief that the judge has to somehow try to seat a jury first, and I'd suggest that is an insidious suggestion. Because as each of the judges on this court knows from being trial judge, there is a lot of momentum. The logistical force behind continuing a trial once it's begun is overwhelming. And in fact, what happened here is the judge very, very intelligently said 3 months before trial, we're going to go somewhere else so that the logistics can be put in place to try the case where it should be tried to ensure the defendant a fair trial and for administrative concerns. So the notion that somehow 3 months before is a mistake is precisely wrong. Here it was necessary to do it in advance so that all parties knew exactly where this case would be tried, so that all the logistical concerns could be put into place to try the case in Plymouth. And the other thing here with respect to, I found it of interest that the prosecutor just a few minutes ago said this was moved off Cape. That is a very telling statement because, in fact, the Cape is an isolated part of the Commonwealth. The Cape is an entity, and it's recognized as such, as is manifested by the term off Cape. The publicity here, primarily by the Cape Cod Times, that is a local newspaper read on Cape. The judge recognized that. The judge sought to alleviate problems with affording a fair trial to these juveniles by moving it off Cape. It may not be Nantucket, and making reference to Tulin, but it is nevertheless, it is not Boston. It's not Worcester. It's an isolated, it's a geographically isolated part of the Commonwealth, and it is a part of the Commonwealth that looks to itself. It has a regional identity, and that is manifested in the media that is available to it and that is digested by the citizens there. I don't know if there are any questions. I really don't. As I said, I'm sort of flummoxed. I was trying to figure out why we were here.
All right, thank you, counsel.
Thank you very much.
May it please the court. I represent juvenile KR number 11034. And I would like to concentrate on the prejudice issue here to the juvenile defendants, particularly my client, who suffers it more than, without due respect, more than my brother's client.
Is yours the third, counting the adult, is yours the third trial?
I would be the third and last of the 3 trials, and that puts me even in a worse position, especially given that the supplement to the record, which I think is very important here, really, it's the fruit that the judge basically predicted was going to happen in the sequence of events here. In my case, my client made some statements. Those statements were suppressed in their entirety for a whole slew of constitutional violations.
How old was your client at the time?
13 years old at the time. And in the wake of that, within 24 hours, there were arrests of the other 2 co-defendants and a very elaborate press conference, video of which is available on YouTube, the judge, that was given to the judge, where the contents of those statements were essentially presented as the theory of the case for the Commonwealth. Not only have those statements been suppressed as to me, but the vast, overwhelming majority of other evidence in the case obtained by search warrant from those statements has also been suppressed, including the entirety of the crime scene evidence. Since that time, particularly with regard to the adult case, the contents of my client's statements, the contents of the search warrants, the identification of 274 Arrowhead as the crime scene, which we dispute, and the alleged forensic evidence from that crime scene have all been the subject of saturation coverage. In the fall, when the adult was tried, there was front-page coverage for 3 weeks straight. This is well after the judge's decision in this matter here, but this is what we anticipated. And all of those things were repeatedly disseminated in every venue, not just the Cape Cod Times, the Barnstable Enterprise, the Barnstable Patriot. We've listed a whole. My brother put together a great compendium here and, to expand the record, to give that attention to the court. And in each and every article, my client is mentioned by name, highly unusual for a juvenile defendant, and the crime scene is identified as 274 Arrowhead. It gets even worse. The adult co-defendant allegedly confessed to a whole slew of people, all of whom took the stand, some with grants of immunity. There must have been 4 or 5 of them getting up there with these confessions. That's brutal material for me in court. And this court has repeatedly found, as has the Supreme Court of the United States, that there's no curative instruction, there's no colloquy the judge can engage in with the jurors that can unring that bell, that can sanitize that. Instead, what I've got a tainted jury pool who's been provided with these, what would be brutal statements, coming in as the jury, potential jury pool in Barnstable County. And it's highly prejudicial. The judge recognized this. Now, the standard here is abuse of discretion, and that standard is that no judge acting conscientiously could intelligently and honestly have taken the view that this judge took. We submit to you that this, even as of the time that he made this decision, there was abundant evidence of that. This whole line of cases, McGowan and Tulin and others that have been brought to your attention, they involve the denial of a change of venue. But this court has never stated in those cases that had the judge gone the other way, it would have been wrong. It would have been abuse of discretion. That's the broadness of the discretionary grant. I urge the court not to consider the proposed rule that a lower court should be required before it can exercise its discretion to engage in impanelment. We have, in our brief, we conducted a survey of every other jurisdiction, and in 48 out of 50, that rule is not adopted. And the 2 that it is adopted, which is California and Nevada, even there it's not required. It's just an advisory rule passed by the legislature, not by the judiciary. what happens if we have that rule is a phenomenon very similar to in investments, the sunken cost theory. You get so immersed in the process that it's hard to pull back. And the judge's findings here were, for their time, they were quite good, quite comprehensive. They justify the use of discretion. If we look beyond it to what has happened since, it only validates the judge's conclusion. And for these reasons, we would ask that the court affirm the sound exercise of discretion of the court below.
Thank you, counsel.